Welcome, everybody, and thank you so much for coming to HGAP Studios to our Something Cool panel, where we interview industry professionals in hopes to educate, empower, and inspire the creative community. Today, we're going to be talking about something very important, which is intellectual property, and touch up on copyrights, trademarks, and contracts. Sometimes these things are overlooked when it comes to creators, but not today, because I have the amazing Carissa Rivera, who is a licensed attorney and specializes in helping the creative community navigate the legal aspects of creativity, and also, which is super cool, helps them protect their creative work. So thank you so much for coming, Carissa.
Thank you, Kendrick, for having me, and thank you to the HGAB team for putting this event together. Thank you to everyone in this room. We appreciate your support, and I applaud your curiosity and your willingness to learn and listen, and I hope to learn and listen from you all tonight as well.
Awesome. Cool. Thank you for coming. That's awesome. I'm super excited, personally. I hope you guys are as well. So we're going to dive right in, right? Because as creators, whenever we hear the words intellectual property, it freaks us out. So can you give us a good representation of what intellectual property is and why it's important for creators to understand what it is?
Yes. So intellectual property sounds like this complicated term because it's nuanced and it's not tangible, but in reality, it can be broken down into a couple of parts. So we have trademarks. That's protecting your branding. So your logos, your designs, your name, those are trademarks. Your copyrights. That applies to everybody in this room right now. All the things that you're creating in tangible forms. So your videos, your photos, your choreography, all the creations that you are making money off of. I would hope that you're making money off of them. They can potentially be copyrightable, and we want to monetize on all of that. And then there's other aspects of intellectual property that we're not going to touch up on today, but that's patents, so inventions, and then there's trade secrets, so secret ingredients in your recipes and processes. So at the end of the day, this matters to any business owner, but especially creatives, because the very essence of your business is creation. So you want to understand what it is that you're doing, how you can monetize it, and how you can protect it and prevent people from misusing it.
Which is something that I feel the creative community down here in South Florida doesn't utilize the most. You know, when you go to other cities like LA or New York, everybody talks about their copyrights.
Usage, royalties,
yes.
all that.
And here it's like the Wild West, even though we're in the East. But it's wild. Like, people will get hired and they'll give up the rights to all their images without even getting compensated for it, because I feel like a lot of it is just a little bit of lack of education and getting to know that side of things.
Yeah.
Would you be able to tell us the difference between copyright and trademark?
Yes. So trademarks, like I said, are for protecting your branding. So something like, your photos is not going to be trademarkable. And I get people all the time coming to me like, I want to protect my trademarks. And I tell them, if you're looking on protecting your branding, what makes you unique and how consumers perceive you, that's what's trademarkable. Versus your copyrights, the stuff that you're creating, the tangible creations, they have to be in tangible formats, and we can discuss what those are in a little bit. Like I have clients come up to me and ask me like, can I copyright my logo? And it's just like, it's a little bit misplaced, but at the end of the day, it's all intellectual property. It's all business assets that you should be utilizing and protecting so that the value of your business goes up, and so that you don't get, your business doesn't disappear in this crowd of other influencers or creators. You stand out, and then you have this asset that you can monetize.
Yeah, absolutely. Anybody have any questions on copyright, intellectual? Yeah?
So as far as trademark and copyright, this is more within this country, correct?
Yes.
Not worldwide?
Yes. So trademarks and copyrights are territorial. So while you can have statewide trademarks, you can have federal trademarks and copyrights because they're governed by federal law. And so I'm able to work with clients outside of the state of Florida because it's federal. If you want to explore international options, let's say your operations go overseas, and you want to look into trademarking or copyrights overseas, each continent or country has their own set of laws that govern that. But when you have a foundation in the US, so you have a federal trademark or federal copyright, it makes way for international registration.
Perfect. Thank you.
Yeah.
Cool. I didn't know that. It's good to know.
The more you know.
Yeah, exactly.
We didn't talk about that one.
We didn't talk about that one. Okay, awesome. So yesterday, Carissa and I had a little meeting just to kind of go over everything, and she educated me so much because I was like, can I copyright creators live here, which is our slogan. And I think you had mentioned you can't copyright that, you can trademark that. So
Ding, ding, ding.
yeah, there you go. So I'm learning already. So super important. So yeah, protect your assets, because at the end of the day, your creations are your assets. And a lot of people don't understand that, yeah, you created it today and that could literally monetize for the rest of your life. That's why actors get, royalty checks every once in a while. Royalty checks? I wouldn't say royalty checks, but they get checks every time the movie gets aired on whatever. So it's important to do that. So thank you so much. All right. Somebody had a question? Of course.
I have a question to go off of what you said. And the question is, what would be the most effective ways to conduct a comprehensive trademark search, both domestically, internationally?
So before we do explore any trademarking, so protecting your brand, your logo, your name, I would run a clearance search. So that's making sure that, one, there's no other marks in the market right now that are registered conducting business similar to yours, and also that you're not infringing on anybody's marks by using your mark for your business. So it's a twofold test, what we're looking for. There's a bunch of considerations. It really depends on the business and what the mark is. And so once you have that clearance and that registration in the US, what I meant by it makes way for international registration is because in a lot of countries, you're presumed to already have these rights because you have a US registration. And a lot of times, and I can only speak generally, is companies are not registering in Europe or in China and not in the US. Like, they come here first because this is where the market is. So once you're registered here, it invites for quicker registration internationally most times.
So you're saying companies will generally start here.
Yeah.
And then once they have it here, it makes it easier to get in every other country.
Yeah. And I definitely encourage anyone that's doing business internationally to look into registering internationally as well, only because you're only able to protect what happens in this country if you have this registration, right? So if you have your design and you're blowing up on the internet, you have this retail store and you're making sales in Australia and Europe and Canada, you're not stopping anybody from using it in those areas unless you have a registration.
Wow. That's scary.
Yeah.
Yeah.
And the world's a big place.
Yeah,
so.
and TikTok is huge.
Well,
It reaches. So is there a way, and I'm sorry, I know you have a question, Gia, but is there a way to register it in one place and have it like spread throughout other countries, or you need to go specifically place to place and do
because
that?
every country has their own laws. So while in the US you can register here and you get this presumption of rights in other countries, they respect that, the US is where the market is and where it begins most times. You still have to go through the laws of the specific country, just like states. If you want to get a statewide trademark here in Florida because you're not doing business in California or Texas and you don't really care what other businesses are doing over there, if you eventually start to expand, your rights are limited to where you're registered or where you're using your mark, which is a nuanced thing, the common law trademarks we talked about.
Right.
But yeah, you would have to get registered in each state you're doing business in, federally or internationally. But I think that the more registrations, the better, right? I mean, at that point, it's maintenance and having a good team to back you and policing your mark so that, you know, if an infringer comes using your mark, you're taking prompt action to demand them that they stop or propose licensing or monetizing off of someone else's use of your marks or your copyrights. But yeah, you still have to follow the law.
Wow, that's interesting. Gia, you had a question?
Yeah, so just a question around trademarks. So it seems like for trademarks, as opposed to copyrights, you're working like with a lot more of a smaller specific set of items that you can trademark, right? All tied to like branding and identity. So aside from logo, name, slogan, what else is under this like smaller trademark umbrella opposed to?
That's trademark.
That's it. So just these three, right?
Your brand name, your logo, your slogan.
Okay.
And if you have multiple logos or multiple slogans, you can also do maybe like product lines because they're brand names. So it's really just words and logos.
So if, for example, somebody launches a series, like a product line, like you said, is that something that has to be trademarked separately in order to benefit from the protection of the bigger umbrella trademark of the brand?
I would say it depends if you're using it like a trademark.
Got it.
And
So it's a
also-
case by case more so.
Yeah, it's case by case. And also if it's a work, like a literary work, and you want to trademark the title, you have rights to the title, but you don't have rights to the words. I mean, you do, but you don't have as much protections as you would get by copywriting that book or that poem. So depending on what protections you're seeking, and what it really is for, that helps us understand like what would best be tailored to you.
Awesome. Yeah.
One more question. So our fan base, for example, is mostly in the UK. Now, if we have our brand, right, we got a trademark, 2018, what's to stop people from another country from starting something similar with the same logo? Like, would they have trouble knowing that we started first in another country, or do they have free will to take the logo and just start the business from start in the new country?
Mm-hmm. Well, I want to preface this answer by saying I'm licensed in Florida.
Got you.
In the US. But if, for example, in the UK, they had a law about common law use and you could prove that you're using it first, then maybe you have an argument there about, you can prohibit people from using it based on your common law rights because you don't have a registration, but you still get this right to trademarks because of your first use. And that's a whole nother analysis, but I will say, having to prove that you were the first one to use it, having to prove that you were there first, all those nuances can be resolved by a registration. So the registration serves as that presumption that I was using it first and I'm the owner and these are the reasons why I'm using it and I have a certificate. So other countries navigate that way. I don't know how common law looks in the UK though.
Understood.
Yeah.
Thank you.
So that registration is the trademark.
That registration is
it?
Is your way of saying, hey, if you want to claim something that's yours and I have this, now you got to argue with the feds that gave me this.
Right.
Like
So rather than going through like, I started this back in 20, God knows when, I have an email.
Yeah, show me the receipts.
It's just better to show the actual receipt and just be like, here, this is what I got.
Yeah.
Yeah. Rather than go through the issues of having to find all that stuff and fighting that in court.
Exactly.
With somebody
You don't
else.
want to have to leave so much room for interpretation or for gaps in your use or in how you're using it. That could just be resolved by a registration. And up front, it is an investment for your business, but it is an investment. So
Right.
that has the potential to grow, to add value to your business. And it's scary to, be an entrepreneur or a small business or a creator and think, okay, I gotta put all this money up to invest in something that might not, but it's going to. It has a return because if you get, not cease and desisting people, that doesn't make you money. But if someone's interested in your product or what you're creating, now you have something to license out. Now you have something to make money off of, not
Right.
just it existing and you saying that you use it or that you used it first.
And it's an investment because that is your product
Yeah.
at the end of the day.
And there's no bad that comes from investing in yourself and in your business.
Of course. And especially if you're dealing with a bigger entity that has all the money in the world and all the legal counsel in the world, that they can just easily take something from you because you didn't go through the
Yep.
due diligence of.
They'll bully you because they know that you don't have the money to defend yourself.
Yeah.
So let's just avoid that and get the registration.
Fair. You heard that? No, I'm kidding. Yeah, so guys, protect yourselves always, right? That's the most important thing. Okay, cool. So we were diving into back and forth between trademark and copyright. But we're going to go more in depth into copyrights because I feel like we were talking a little bit more on the trademark end rather than the copyright end. And if you can just kind of refresh our memories as far as like what copyright means and what you can protect in the copyright.
Yes. So copyrights protect tangible authorship of creations. It's like a nuanced term of art. It's like authorship, first of authorship or something like that. It's like this, it really just means like if you created it and it's unique, you can protect it. And that is, like I said, videos, photos, choreography, poems, books,
Songs.
Yeah, sound recordings, beats, all that stuff. So if you're creating it and it's in a tangible form where somebody can copy it, you have the copyright. That's literally what that means. So you have the exclusive right to copy it, to use something in a certain way, to reproduce it to the way that you want. And so when you think of IP, trademarks and copyrights and all that as an armor that's protecting the stuff that you create so that you have control over how it's used, who uses it, when it's used, how much it's worth. I mean, I don't see the negative in that.
No, absolutely not.
Yeah. So yeah, that's copyrights.
Okay, cool.
So
I get it. So
all the artwork.
Anything that gets created
Yeah.
from you as a creator.
Yep.
Shane?
I have a question regarding AI, and I know copyright and trademark. There's been a lot of challenges just with AI content and people trying to figure out how they do this, like what. So I just wanted to hear any insight that you could give us about the current state of AI and copyright and branding.
Yeah, so that's a great question. I'm personally a fan of AI. I love that it's a tool that can help us do things quicker, more efficiently, but I definitely don't think it's the end all be all. It needs to be proofread, it needs to be checked, and it needs to be monitored. And with regard to creations, so trademarks, I mean, you can use AI to create a logo or a slogan. Is it open source? Are you getting it from other people inputting information? You work with an attorney to figure out if you're infringing on someone else's rights for that. And then copyright, actually the US Copyright Act defines copyrightable material as created by humans. So at this time, if you're using AI to create something, a work of art, music, design, artwork, you need to claim that a human made it for it to be copyrightable. I anticipate that law is going to be revisited because of the surge of AI and computerized, digitized work. But also, if a human did assist AI in making something, then you can say that it was made by a human, right? It depends who you're talking to. Are you the creator or the person that is fighting that made AI? What side are you on? And how would you want to be? Would you want it to be protected, or would you argue that it wasn't created by a human?
Tricky.
Yeah.
And it's going to get trickier, I feel.
Yeah, exactly.
Yeah.
So all the facts and circumstances really matter. Every detail matters.
Right.
Trying to figure this out.
You just blew my mind because we're thinking that AI is the one creating it, but we're prompting the AI to create those things. So technically there is a loophole saying that we created it. We just got the help of AI.
Yeah. Or some people say that's generated by AI using other people's works, potentially infringing on other people's ideas and stuff. And that's why I recommend, if you have an idea, if you have something novelty to your business, or something that you think should be governed by an NDA, don't be putting that into ChatGPT because it's spitting it out to the next person that looks up something like that.
Because any information that you're feeding into the AI,
Yeah.
it's basically learning that and pumping it out somewhere else.
Yep. ChatGPT at least.
Yeah.
There are companies and law firms and professionals that use maybe closed source AI, so it's learning off of what you're putting in only, not Wikipedia, not Bing, but for ChatGPT at least, it's pumping out what the next person, what the last person just Googled or ChatGPT.
Yeah.
Is that gonna be a thing? Is that gonna be a verb?
Probably.
ChatGPT, GPT'd.
Did you just ChatGPT me?
You ChatGPT'd that.
Gia, you had a question?
Well, I think you should trademark or copyright that right now, right? The verb for ChatGPT.
Facts.
Just saying. But just on the conversation of AI, so I'm assuming that a lot of the current legislation is around generative AI, right? Or is it around AI used as a non-gen AI tool?
Generative. Only because that's
so if you use like ChatGPT to like help you in your non-creative organizational process within that, is that considered like messing with the law?
I don't think messing with the law, but it definitely does bring up questions of how much did the AI participate in creating something? How much is human creation and how much is AI? Are we going to apportion the percentage of ownership or what's copyrightable or protectable by what's created by the AI? It gets confusing, right? So until we have case law on point with, this is how we address generative AI created works or ideas, then we're really just going off of it depends and arguing the side that you want to overcome it.
Can I say kind of an example that might help illustrate? So, because you were referencing books before, right? So you write a book from scratch, not using AI at all. But for example, when you go in to proofread or to do like a first pass edit or something and you use AI as a tool in that proofreading process, even though it doesn't intervene creatively in the sense of create, produce, is that problematic for a book, for a final product of a book, just as an example?
I think that if my client is using AI like Grammarly or any of these programs to proofread, I would say that creatively the AI is not participating in the creative aspect and it's human made. But if somebody's trying to argue that AI created it, then they would have a different position, right?
So you would have to consult like a professional, even if you're using like Grammarly to proofread a book. Would it be the kind of situation where you should consult someone? Or in a Grammarly situation, it's like, okay, you'll be fine?
I think
That's a good question.
Yeah, I think
It's
consulting.
hard. I can imagine it's nuanced, right?
Yeah, it's nuanced, and I think if you have any doubt, err on the side of caution.
Perfect. Thank you so much. Thank you.
You should ChatGPT that.
GPT it.
Before we jump off the subject, but Grammarly, if you just deny till you die, like how is anybody going to provide the evidence that Grammarly even touched it? Like Grammarly can never get subpoenaed for like
They couldn't.
I'm
Metadata.
asking for data, like metadata, like if it like would it go that far?
I guess it depends. Why would it go that far? And I'm not gonna tell you to lie, but maybe you can. Don't clip that. You don't gotta tell anybody you use ChatGPT.
No, exactly. That's my whole thing. Like it's like if you're the only one that knows.
But I will
How's
say,
that ever gonna hold up?
Because when you're filing for a registration, whether it's a trademark or a copyright, you're attesting that this information you're putting in your application is true.
Yeah.
Under penalty of perjury. So you want to be perjurized?
Yeah. No, it's an interesting part.
Yeah.
Well, I'm mind blown already. Thank you so much for that.
We should use ChatGPT for this.
These questions that I ChatGPT to.
He's not lying. We did.
I totally did. Okay, cool. So let's go back to copyrights. Okay, so I think this is a question that a lot of people will have or might have already thought of. But as a creator, let's say I post a photo or a beat online. Do I automatically own the copyrights to that image or that beat just because I posted it online and I made it and it's just out there in the world? Do I automatically own the copyrights to that?
So it's a twofold question because all of these platforms have their own fine print. So while you need a medium to post this creation on, right? If you have a photo or if you have a beat, you have to post it somewhere. And you can't just create your own program just to post your beat or your picture if you don't have the resources. But when you use Instagram, for example, or SoundCloud or something to post your work, you essentially are, in a way, probably licensing Instagram or these programs to have your work on there. I personally have never read the fine print, if I'm being honest. Who's gonna read 58 pages of size 3 font? But no, you don't lose your rights. If anything, I would argue that you create your rights because that's your tangible publication of this work. And so I think a lot of creators, the issue that we run into with social media is people reposting or republishing your work without permission. And so there's this great tool that the Copyright Office has. It's called DMCA Takedown. Maybe you guys have heard of that. It's the Digital Millennium Copyright Act. Me and my dyslexia. So you basically get to, if you see somebody repurposing your works without permission, and you know whether you want it there or not, I would say you should use the takedown tool. You get to tell these programs or these platforms to take that stuff down because you're the copyright owner. So a good example of that is YouTube has like an automatic tool where it's scanning for royalty music. And if you have royalty music, it's muted. Because if not, YouTube is going to be flooded with DMCA takedown notices asking people to take down, you know, the videos or shorts and stuff like that. So while you are probably licensing your stuff, again, I haven't read the fine print. I think there's arguments for saying this is your publication, this is your display of the art, and also you have tools in place to prevent other people from misusing your creative works when they're published on platforms like that.
So you're saying this tool that you're talking about, rather than, let's say I create a beat and then I see it being used on somebody else's platform without my permission, rather than me going directly to the person who posted it and telling them to take it down, you use this tool, and then this tool will go directly to the platform which is hosted on, and it will take it down.
Yes, but I would say reaching out to the publisher or
It's
whoever,
probably better.
I would say that's your first step.
Okay.
Right? Because before you get the legalese and the terms and the notices and the attorneys involved, you want to have a human conversation. Like, hey, you didn't ask for permission. And it's as easy as asking for permission, right? Because maybe you don't want to monetize on that, or
Right.
you don't see it's a SoundCloud rapper with 3 followers, and you're like, they ask you to use your beat, and you're like, you know what? Yeah, you have permission.
Well, today they have 3 followers.
Yeah. Until you use that beat.
And then they freaking blow up because they're using your beat, and they're not like at least giving you, you know,
Yeah.
like putting your name on it,
Yeah.
which is nice.
Yeah.
You know.
Credit helps, but money helps.
Yeah.
Pay the bills.
Facts.
Credit don't pay the bills.
Facts. Okay, that's good. I had another question. Let me see. Completely forgot. Let me use my ChatGPT questions.
Yeah.
We spoke about this yesterday. Ideas. Can you copyright ideas?
No. You can have $1 billion idea and it's not protectable by copyrights until you have it in a tangible form. Because how can someone copy something that it's not copyable? But I will say, if you're sharing your idea with people and you don't have an NDA in place, then you just gave away your idea for free. then you're stuck proving that I had the idea first, or I communicated it to them, or
Right. Because I was like, you know, oftentimes we have entrepreneurs sitting around in a table just shooting the shit and throwing out great ideas.
Yeah.
And then all of a sudden somebody takes that idea and makes it happen. It's very easy.
Yeah.
So before you share anything with anybody, the best way to protect that idea is an NDA.
That sucks, right?
Nah, that sucks.
That you have to like get this, like
I-
you have to have writing before you share stuff with friends, but you got to protect yourself.
Yeah.
Again, like erring on the side of caution.
Yeah. Because an idea is just an idea until somebody is able to make it happen.
Yeah. And maybe you have this idea and you haven't acted on it because you don't have the resources or the
Right.
team or the knowledge yet.
But that person does.
That person's ready.
Gia?
I actually have two questions tied exactly to that. So, first of all, I think it's really cool that you brought up the NDA, and I think it might be something that we need to learn a little bit more about. At least I can speak for myself. I don't know. I have signed NDAs. I am currently under NDAs and stuff, but like when you're the person issuing it, right?
Yeah.
I feel like for a lot of like for independent creators, you're always like on the side of signing an NDA, right? You're not usually the one to be issuing. When you're not this big organization or this big, out there, how do you go about the NDA stuff for protecting ideas that aren't yet in a trademarkable state?
I would say get over that fear of this person's not going to do business with me if I ask for a signature, because you need that signature to protect yourself. And so the first step would be asking the hard question, hey, are you willing to sign this? You can always negotiate the terms of an agreement if it's like, this is too stringent, this is too restrictive. But I would say encourage that something gets written and that you're protected. As for working with smaller creators or smaller businesses and getting documents signed and getting NDAs, we can create something that not templatized, but something catered to your business, to your needs, so that you're not consulting with an attorney every time you need an NDA. You have something that protects this idea and this project that you're working on or this system, and you can repurpose it for other people depending on who the recipient is.
That's awesome. And just tied to the NDA thing, how, like, it in real life, how enforceable is everything tied to an NDA, especially when you're not the big corporate person with the human power behind it to how enforceable is it? Like, if you're an independent creator, you do the whole thing, everyone signs the NDA, but
stuff still leaks. It depends how much money you want to spend. And that's just the sucky part about litigating and defending yourself and policing your work, that you got to actually put your money where your mouth is. So if you want to stop people from doing that, if you want to stop people from leaking your idea or, pursuing something that you shared with them or reproducing your work, you're going to have to pay. And going to court is not cheap. It's a long process. It's expensive. And so a lot of times I will prepare language for disputes to be resolved by mediation or arbitration, so that we're avoiding going to court, spending that time and money, and instead reserving that time and money for your business, and things can get negotiated, worked out, settled one-on-one. Yeah.
That was a good question.
My question is, so you mentioned you can't copyright an idea until it's tangible. What about a concept? Like, per se, mine is a niche that I'm trying to target, right? So can I copyright a concept, I guess a process? I don't know what it would be, but I'm trying to target a certain niche.
Okay.
So can I copyright that?
If it's not tangible, I would say no. Maybe what you're looking for is, you are able to protect processes and systems if they're unique enough and if they're novel enough, and that's something that you could maybe consult with a patent attorney, because that protects inventions and processes. Again, in many ways, they have to be tangible or written or, accessible. It can't just be something in your head that you wrote down.
Right.
But and it just depends on what it evolves into. If it's something that you're creating and it ends up being a product, then maybe that's something that's patentable. If it ends up being a work of art or something, then maybe it's copyrightable. So, but once it's in tangible form is when we'll really know. The thing that's cool about trademarks, although you can't protect, a creation or the actual product. You can protect the branding. You can actually get apply for a trademark before you even start using it. So if you have an idea to use a name or a logo, before you even start using it, you can file an application for it. It's a long enough process that by the time you start using it, you could convert your application and then actually get registration. But you hold your place in line so that during this long process, you're next in line for getting that registration once you start using that brand, logo, slogan.
So it's never too early to start and just...
Never too early.
Okay.
The earlier, the better. If it's an idea, consult with someone that's under an NDA consultant or an attorney. Even consultations with attorneys are bound by attorney-client privilege. So if you have a consultation with an attorney, they're not allowed to say what you guys talked about or share your ideas. So
Okay, thank you.
I'm gonna piggyback from you. So let's say if I have an idea and I have a concept and I write it down and make, for example, a presentation, a business plan. How can I protect that thing? It's more protectable, the idea, or not?
I would say by an NDA, because
So an NDA.
what is your objective? Are you trying to prevent other people from like getting to that idea first,
Yeah.
or from repurposing it, or
I think what he's saying is he has a great idea for a business,
Yeah.
And we
you
gotta
want to
talk
pitch it
after
to an
this.
investor, but you got to give the presentation.
Yeah.
So I think what she's saying is
You have
have
to
them sign an NDA before you even talk about anything regarding that idea or that business.
Yeah.
And I think Gia had mentioned, that she has given NDAs out and people don't want to sign them. Good. If people don't want to sign your NDA, that only means that person is going to be very hard to work with. You don't want to work with that person.
Yep.
Don't have them sign it. Be like, okay, perfect. I'll go on to the next person.
Yep.
Thank you.
Don't bend on your value.
Yeah, because that idea is worth way more than whatever money that other person is going to give you for that investment and so on and so forth. So
Yeah, there's a ton of investors, and there's a lot of people that will respect the value of your work and the integrity of your process and what you need to put in place so that you can do business with them. And at the end of the day, you don't want to do business with somebody that's cutting corners. And why
And
don't
being
you
sleazy.
want it in writing?
Exactly. That's already scary enough, especially here in South Florida.
Oh my gosh, yeah.
I got here late. I don't know if we're on a specific topic, so I'm going to ask a question. You
It's
guys could be like, not it.
It's an open format.
Okay. This is something that I've been kind of dealing with more recently. So I have like my own creative agency to the point where like I independently contract people if it's like a bigger project. And I'm realizing there's like a sticky space, and it's maybe NDA again is the answer, but I'm just curious what you guys think about this or if you've had an experience with it, where if I'm contracting a team, how do I protect that it's still under my creative direction and like my business? Like I'm big on, I love when people do posts and credit every single person that's been involved in the process. That's huge to me. I feel like we don't see it enough in the creative space. But something, I don't know if it's a template to kind of let the people know who are working with me, this is under this agency. Still giving credit to everyone who was a part of everything. You know, I'm not here to say like I was the person who did this and this. I want to acknowledge the team, but acknowledge that it's under my agency, and kind of protecting my portfolio where it doesn't slip into other people's portfolios. Do you have any recommendations for that?
We spoke about this yesterday.
We did?
Yeah. So
What are we
Or
talking about?
maybe you have
So,
experience.
yeah.
Exactly.
So what she's saying is, she runs an agency. She hires out people to create these works of art for these companies that she brings in. And then these creators go ahead and post it on their own personal platforms, whether it be their website, their social medias, and so on and so forth. And they may or may not give credit to the agency that hired them for the work. So
Okay, I understand.
in that regard, it's all about the contract, and you can,
Yep.
okay.
Yeah, we're on the same page.
It's all about the contract that you give to that creator when you hire them on
Yeah.
for that work.
Yes.
Yeah.
And there's,
You learned
yes,
yesterday.
dude.
Yeah.
Well, I learned because not only did we spoke about it yesterday, but I've been on both ends of that.
Same.
You know, because I'm also a creator and I work with
Yeah.
other agencies. I own my own agency, so I work with other creators. So it's a back and forth. And I've had situations where the company says for hire,
That's where I was
right?
going.
So when you for hire someone,
Yeah.
that means that the work belongs to the company that
Company.
hired
Yeah.
that creator. That's what
Perfect.
you taught me
You hit
yesterday.
the nail on the head. I was
Yeah.
going to say work for hire contracts or provisions in your contract with the contractor. And also, you can throw in branding guidelines, right? So if they're going to be reposting this stuff, these are the conditions. You can give credit to my agency and you can tag the client or the product or
Yeah.
whatever the brand is. You have to use these hashtags. Or you can limit their use altogether, right? In your contract, you can say that you're not allowed to repurpose this. This is work for hire, completely work for hire. That's for my portfolio. You can't use
Yeah.
it for your portfolio, for your marketing, for your business in any way. And that's something that they're gonna have to talk to their attorney about, because if they're contractors and the work that they're creating is work for hire, then that's something that they can go back and forth and negotiate with you. But I would say having that in place will protect you and be a good foundation for making sure that there's no overstepping or confusion about who's the client and who got contracted to. This is your client,
Yeah.
or like this is somebody that you work for, or so. And making sure that your contract has clear terms so that that's clear and there's no misunderstanding.
Yeah.
And not just clear terms on the contract, clear terms in speaking to that individual
100%.
from the get.
Yeah.
Like, hey, this is what the terms are.
Yeah.
That way you don't send contracts, you negotiate rates, and then when they read it in the fine print of the contract, they're like, wait, what's going on?
Yeah.
If you vocalize from the front end, you'll save a lot of time.
Yeah, I've learned. I feel like, because I've been on both ends of the situation. Not that I don't like to give the creators credit for something that, I mean, it takes so many. It's a collaborative effort to come up with these things, to put this together, like so many things. But I've been at the end of something where I'm like, oh, this makes me feel a little icky. I don't think this is how I should have communicated.
Yeah.
So yeah, it's like, I guess it's communicating, and then of course the contract always.
Yeah. And you
Yeah.
have to have gone through this to know what works or doesn't work.
Yeah.
Or what you like and don't like. So
Yeah.
it's growing pains.
Yeah, for sure.
Being a small business, being an entrepreneur, figuring out what you want out of, the business that you're doing with people.
Right. And I've done a lot of work for hire
Yeah.
where it's theirs, but I communicate and I say, hey, I really would love to post this on my end. Would that be okay? And I want to say 90% of the time, they're like, yeah, totally.
Okay, because sometimes businesses or brands will be like, immediately just letting you know, like, this is ours, like, whatever you create. Sometimes I wonder, is it overstepping to be like, hey, I would love to show what we did, because I feel like we're going to get turned down. But it's nice to hear that a lot of times they say yes.
It never hurts to ask.
Yeah.
Especially because you've been through the shits with them.
Yeah.
And you become
I'm
like,
guys, we did this together.
yeah, exactly.
It doesn't hurt to ask, but it hurts when it's not in writing.
Exactly.
Because you don't want to
Yes.
sign a work for hire agreement and then verbally you guys agreed to post for your portfolio, and then they come back saying you got to take that down. I didn't give you
Yeah.
permission, and this is the contract. Because at the end of the day, what's in writing and signed governs. So you guys can have this conversation up front. You can have this conversation after, but if it's not in writing, there's an issue.
right. And whenever I ask, I always send an email.
Yes, follow up.
I never I might be like, oh my God, this is so cool, but then
in writing.
Yeah.
20 minutes later, I'm like, hey, just to confirm
Yeah.
that I can post this so I can get the okay. And then later, if something happens, I can be like, no, I got.
Yeah. In that case, you want to look at your amendment or modification provision of your agreement to make sure that you can have modifications in writing agreed by the parties, and that's not something that has to be signed.
Okay.
Because they can still say that that's not
Yeah.
an enforceable modification, and you got to take that stuff off your portfolio.
It's true.
So you want to know what you're signing. I mean, I think this is a good segue to get into contracts.
Yeah, absolutely. This is a great segment to get into
Yeah.
contracts.
Well, thanks,
okay,
guys.
cool. Thank you for that question. And then also, it's important to know who to ask, because that person might not have the exactly,
authority.
and they'll be like, "Yeah, totally, it's gonna be great." Let's go to dinner after.
That's a great point.
and then you put it up, and then you gotta cease and desist. It's beautiful.
Just post it, girl. That's so good.
Okay, cool. Let me look at my chat GPT notes. No, I'm kidding.
No, you're not.
I'm not kidding.
The GPT.
Okay, cool. Let's talk about contracts, right? Because that was a great question. And I feel like a lot of times creators love to create, but they're just so scared of sending a contract to somebody. And at the end of the day, they get burned. And, you know, I think you and I spoke about it. Like, sometimes lessons are better learned the hard way.
Yeah.
Which is kind of true, because we wouldn't be where we are today if it wasn't for failure. And I think that's beautiful, as I said it earlier. But let's talk about everything contract related when it comes to creating something, not only as a team, collaborative effort, but for companies.
Yeah.
So, like, what about my first question? Did you have something to say?
No, I was just gonna go off of
Yeah.
off of what you said.
Okay, go for it.
So let's talk key contract terms for
Yes.
creators. So are your deliverables clear and the scope of work? That needs to be on point. If you're the service provider, I would say, and I always tell my clients, like, don't include stuff in there that you don't plan on giving them. Provide more than you put in writing.
Right.
Because that's legally better than promising all this stuff and not being able to deliver. And if you're the person receiving the service, you would want every detail of the service you're receiving, because that's what you're paying for. Payment terms.
Mm-hmm.
Let's not just put a price. Let's say when you need to pay by. Is it upfront? Is it after? How much after? What method of payment? Because then are we talking on the side about Zelle me, this is my info? Just throw it in the contract. Something I like to do is I'll prepare a master service agreement and I'll have schedules attached so that you can modify your scope of work and the payment terms depending on the client. Because it's not always one size fits all. Sometimes there's clients that you want to be a little bit easier on these. You can pay me by the 15th of the month, not the 1st, not the 7th. Maybe, you want to tweak it and feel like, you're giving your client full service and also something that's tailored to the relationship that you have with them. But you're still protecting yourself and the terms are clear. So scope of work, deliverables, payment terms, and most importantly, your IP. Mm-hmm. Sometimes I see creators that have contracts without any intellectual property provision. Mm-hmm. And whether it's, you're producing videos of live events and you have to make sure that the venue doesn't have infringing IP, because then it's on your end when you're publishing this video that you're displaying infringing content, or you're protecting the content that you're creating. You need IP protection in your agreements. It can't just be like, I'm going to provide this content and then you're going to provide this product and let's call it a day. Like, let's make sure that everyone has their obligations, that they're completely understood and that they're followed. And then we talked about indemnification and limitations of liability. Those sound like such crazy terms, but just to break it down, they're probably in every single contract you've ever signed. Indemnification is if you get sued by a third party, the person that hired you is covering you. Mm-hmm. They're holding you what's called harmless and defending you if something happens. So a good example of why you would want this is, let's say you are a photographer and you're shooting an event and then you're producing these photos for the client and then they're publishing them on their personal website or something. And then you get hit with a demand saying, hey, these pictures you're credited on here, my products are in your pictures, or my brand is in your pictures or something. Like, you need to take that stuff down. The person that hired you, that's repurposing the pictures and that hired you to take the pictures, they need to be responsible for a third party claiming that you infringed. Or, if something happens like that, you don't want to put money up
right
for a work that you were hired to do.
Right.
So indemnification is going to help you with that. And then limitations of liability. You can cap how much somebody can recover for a breach by a certain amount. So most contracts I'll include, a cap of the contract price. So if somebody breaches the contract, the most that you can get back hiring me is what you paid me. We're not taking my car, we're not taking my business assets, we're not exploring, 150K in court. Like, the cap is what you paid. And it makes it much easier if issues do come up. But we like to practice preventative law, okay? So we want to limit your exposure and your liability, but if issues do come up because they're inevitable, then we have a process in place for how we're going to navigate it, and having clear contract terms are the first step to making sure that you know what's going to happen if something falls apart.
So just to kind of recap, you're saying key elements to have in every contract as a creator.
Yes.
And as somebody hiring a creator should be scope of work, very simple, payment terms, timeline, usage rights.
Yes.
Yes.
IP. That's all IP.
Mm-hmm. And cancellation clauses.
I didn't say cancellation, but we can talk about that.
I think it's important because a lot of the times, and we spoke about this
Your
yesterday.
force majeure.
My force majeure. Not only, are there unforeseen circumstances like force majeure that we don't know what's going to happen, a hurricane's going to come on the day that we want to shoot, and somebody's trying to sue you because the damn thing didn't happen. People couldn't drive in the streets. So that's important. But projects get shelved and you don't get paid. Or projects get shelved and then 6 months later, they're like, oh, okay, we want to pick up on the project again. And you long gone forgot about that. And it takes a lot of time, energy, resources to get that project back on to finishing it. So one thing that we definitely have added into our contracts is, hey, you can't take 6 months, and if you do, there's a fee for that. So super important. And then obviously cancellation clauses. Sorry.
For that timeliness thing, I like to include obligations. So there's an obligations section for whoever's hiring you to create the content, to produce the work, that they're going to respond timely, that they're going to review content timely. And there's also this simple phrase that can be included in every contract, and it's time is of the essence. Because if there's delays, there's cancellations, there's rescheduling, there's fees. I love to add some fees.
Yep.
Especially if you got that credit card on file already.
Well, you need to have skin in the game, right? And we spoke about not just having a contract, but having your clients pay you a deposit, right? Because a lot of the times, if there's no skin in the game, then they'll take forever to do anything. And we spoke about it yesterday on the payment terms. A good chunky deposit, whether it be 50%, that's kind of, it's up to you.
80.
80%, whatever it might
80,
be.
take it or leave it. I'm just kidding. Whatever works for your business. But yeah, definitely deposit so that your availability, your resources are reserved. And like you said, when you have skin in the game, are you going to just let that money go to waste? Also include that non-refundable language.
100%.
Love that non-refundable deposit.
Yeah. No matter what force majeure happens, you're not going to get your money back. No, I'm kidding. But yeah, definitely important. Does anybody have questions on that? What to include in your contracts and what to look for when you're getting hired out by other entities?
I have a question for the crowd.
Okay.
How many of you have read your entire contracts that you've signed? The entire thing. How much of it did you understand?
Okay, that's fair.
You don't count. How much of it did you understand?
Not a lot. I mean, I put it in Gemini and ask it to simplify and summarize.
Yeah. I would, honestly, that's a pretty good first step to understand if what you're signing is hurting you or not. I know that using these AI tools, you can also narrow it down to who the party is. So if you're putting it in Gemini that you're the service provider, make sure that these terms are pro service provider or pro client or the person receiving the services. That could probably help, but I would also err on the side of caution putting contracts into AI because sometimes contracts have confidentiality provisions. So you're not supposed to share the terms of the contract with anyone, including ChatGPT
and Gemini.
Including GPT. So
good to know.
Yeah. So be careful. Don't tell anybody you're doing that.
Do contracts have to be 5 pages long and super hard to understand?
It depends on the business and the objective. Like an NDA doesn't need to be more than 2 pages long. But if you're a software developer and you're developing this AI generative code and all, if you have a 5-page contract and it's bullet pointed and you did it through ChatGPT, chances are you're not protecting yourself. If you have a writing, you're one step closer, but a writing is better than no writing.
Right.
But chances are 5 pages isn't covering what could happen.
Right.
So I applaud, business owners that have these 13-page, 26-page contracts. But if half of it's nonsense, then it doesn't matter. So you want something that's intentional, that's purposeful, and that achieves what you're aiming to achieve with the agreement, right? What are you protecting? Who are the parties? Is it on point? Because you don't wanna have to argue that something applies when it just doesn't.
Right.
Which is the good thing about having flexible agreements for your clients. And also having an attorney to proofread, redline, consult with you on, what could potentially harm you or what could be added to protect you.
Mm-hmm. And I had asked you, why can't I understand these damn contracts? Is it because I need to hire an attorney to be able to read it?
Yeah. Or in the event of including but not limited to.
Right.
Because if you use it's so true. And I read it now and I'm like, this is English. But if you read it and you really dissect the language, if you use plain language, you're not going to protect enough. Mm-hmm. So an example would be, including but not limited to these instances. And someone says, we can just put including these instances. But what happens when an instance happens that's not listed? It's not covered. So we have to use all of this nuanced, creative language to protect as much as we can. And although no contract can fully protect you, you can't anticipate every possible situation or every possible, thing that goes wrong. If you have, terms that you understand, a process that you actually follow, then you're able to navigate issues easier.
Right.
You're
saying that plain text could be misconstrued in many ways.
It could just not be sufficient enough.
Right.
Because maybe plain language is easier to understand, but it's also easier to go around.
Right.
Yeah.
Yeah. Okay, good to know. So the more if, thens, and buts are in the contract, the better.
The if, thens, maybes, including but not limited to's, yes.
That's amazing. And what about a contract that's written on a napkin?
Yeah. So it's funny because Kendrick said, what if we just write it on a napkin or something? And, this is there's a case that you learn when you're a first year in law school. And it's just to emphasize how binding and real it is when you have something in writing that 2 people agree on. Because there's some agreements that don't even need to be signed. But if you have it in writing, it's enforceable. And so even something on a napkin is, this is what we're doing, this is how much, and we both agree. Here are our names. These are the parties.
Like you said, at least it's in writing and it's something. It's better than nothing.
It's better than nothing. But we don't want bare minimum.
Well,
that's not the best.
Touching up on the bare, 100%.
Uh-huh.
But going below the bare minimum, what also can be used as a binding contract that hasn't been signed or notarized and all that good stuff?
Emails and texts.
Right.
So don't overpromise because you might be bound.
The thumbs up.
The thumbs up.
Thumbs up emoji.
You want to touch on that?
Yeah, absolutely.
Go.
So I was talking to her yesterday when we were kind of discussing everything. And I read of a case that 2 people came to an agreement. And when they asked, like, okay, we're going to do this, this, and this, the other person sent a thumbs up emoji. And she read up on it and she kind of looked it up, and it basically, I don't want to say screwed because he gave the thumbs up.
It depends who you're defending. Are you the person that thumbs up or are you the person that received it? But the court determined that was acceptance and it was a binding because someone said, this is what we're going to do. And they said, yep. And socially, thumbs up is yes, confirmation, all of the things that would signify acceptance.
Right.
So
And it's in writing. So
and it's in writing.
you guys have to be extremely careful as to what you guys and how you guys communicate. And also get it in writing.
Yeah.
Again, that phone call was great. But then, hey, just to circle
Send that
back
follow-up
around.
email.
Yeah.
That follow-up email is important. And I would say there's some things that maybe you don't want in writing, and you can pick up the phone. You can have a Zoom meeting that's not transcribed by AI.
Right.
So you can work through things, but then ultimately what's in writing, it's what's going to bind.
What goes?
Yeah.
What about, I know verbal contracts aren't really binding, but unless you have it like maybe in recording, would that still stand in court?
Is that a misconception I hear? Verbal agreements are binding. There's certain agreements that have to be in writing. There's certain agreements that have to be signed, but there are types of agreements that can be agreed to verbally, especially if somebody starts to act on it. So let's say, and that's something that we talked about, is let's say you hire somebody to mow your lawn and you talked about it, whatever, fulanito was in the Walmart parking lot and you're like, hey, come mow my lawn. Guy said $100 and you agreed. Then he shows up. He has all his equipment. You got him on the Ring camera showing up, and he just decided he wasn't gonna mow your lawn. And now you're like, okay, my lawn's not mowed. This guy agreed. I mean, I don't know if you're gonna sue fulanito in the Walmart parking lot. I don't know how much asset he has, but he did agree, and he did take an action towards a meaningful action towards providing the service. So maybe you can say that was a binding agreement, right? Verbal agreement. And it also just depends on your facts and circumstances, case by case scenario for sure.
One thing that I wanted to ask you yesterday was contractors.
Yeah.
Here in South Florida, we have this major issues with contractors promising X, Y, and Z, and then halfway through the work, they just like.
Well, what that scope of work look like?
True. But hey, he bought the damn lawnmower and he was at my house.
If I was the contractor's attorney, I would say put the bare minimum. We're doing X, Y, Z. If I'm the person, if I'm the attorney for the person hiring the contractor, I'm like, put X, Y, Z, put the type of equipment that they're using, put the type of tools that they need to bring, everything. You're putting every detail. It just depends on what side of the agreement you're on.
Right.
Yeah.
Cool. You got a question?
To go back to the thumbs up,
Okay.
that's crazy, and I didn't know that. So these mics are great, by the way. How often would you recommend revamping your contract for this exact reason, like with the internet and all of this stuff going on? Like, I feel like I'm passing a test from your reaction. You're like, oh, you're asking the question.
Yeah.
Oh yeah, we're gonna have a pop quiz after this.
But yeah, like how often? I mean, I'm gonna be real. Like my last contract, God knows how long. It probably was when I started a long time ago.
Yeah.
So it's over.
Yeah.
But yeah, like how often would you recommend revamping those contracts?
Once a year, especially if your operations are evolving, if your clientele is evolving. Something that you prepared 10 years ago might not even apply anymore, and you keep using it under the assumption that, I'm the same person, this is the same business, but there might be terms in there that just don't apply. Something else that's important is making sure that you're actually following the processes that you have in your agreements. Because if you have something in writing and you're not following it, then what's the point of having an agreement? Especially if it's a service agreement and you're a service provider. So you want to be true to the writing. It has to actually, conform with the way that you're operating business. And if your business is evolving, then so should your paperwork. So 1 year.
Cool. Thanks.
I nodded because I had the same question yesterday.
Yeah.
Okay, yeah. I'm
Yeah.
like,
And I said
thumbs up
5
freaks
years
me
at
out.
first, and I was like, actually 5 years is crazy. So
Yeah.
much can happen in 1 year.
And the
I'm like,
laws change.
Laws are
That-
constantly
Yeah,
evolving.
that was gonna
Yeah.
be my
Yeah, that's
question.
another thing. Like one topic, I'm not even gonna get into
Yeah.
it. Actually, it's too nuanced. We're gonna get into it too hard.
But yeah, I had the same question
Yep.
yesterday, so that was a good question. Cool. Anybody else have any questions on contracts and how to protect thyself? You have a question? Absolutely not.
How do you piggybacking on the recording? How do you verify a verbal agreement, or how do you verify how valid that napkin is? Like, how do you verify that is it by handwriting, or who signed it? Like forgery, for example.
oh, we getting into criminal.
Yeah.
He needs a handwriting expert here now.
Because who's to say someone else
So
wrote that napkin?
you see all the
or-
questions you have. Imagine if you're not one of the people in the room when that agreement is being made. So it's a he said, she said situation. Like that's why
Right.
you want it in writing and you want it signed so that what we agreed upon is here. It's clear. Like this is what
But
what
there needs to be a
governs.
witness, or like.
I'm like, no, there doesn't have to be a witness. The writing governs, but
But he's saying like, let's say that contract is forged.
dude,
Right?
that's crazy.
That's
Well, yeah, it's
crazy.
crazy, obviously.
Yeah, I know,
but-
it's
I mean, that's
But it-
first
but-
of all, that's illegal.
But it happens.
right. But do
I
people
wanna
get
say,
away with
I
it?
don't know.
Do you get away with it? No, then
No,
you have
I'm
to
saying-
then you have to sue. You have to sue for fraud, for forgery,
right.
for all the things. But yeah, no, let's not. I'm manifesting nobody has any forged paperwork or gets forged.
No, for
Please,
sure.
Jesus
No,
Christ.
that's a monster on its own.
That's toxic. Whoever that is, get them out
And
of your
Serge, you
life.
had said a verbal contract. Can you record the person?
Yes, that's if you have their consent. Which, if they want something in verbal, then chances are they're not going to consent. And at least in Florida, you have to have both parties consent to recordings, or else it's a federal offense.
Yeah, you can't just tape
Yeah.
record them without them knowing, and then show up to court and be like, "Oh, but I have it." You're gonna get in trouble
Yeah.
federally.
Or at the very least, it's not going to be used.
Yeah.
Yeah.
And then now with the Zoom calls, and it happened to us yesterday.
Yeah.
She was telling me that you can't record somebody because it's federally illegal, and I was like, "Well, I'm recording this conversation right now."
Where did I consent to that?
And
No. It was.
But obviously, like, not like I wasn't doing it to harm anybody.
It wasn't
was
a legitimate. It wasn't a legitimate recording. It was the AI transcribing the Zoom, and so I think that it depends on what side you're on. Are you trying to claim that this person's recording, or are you trying to claim that it's just transcribing through AI?
Right.
So it depends what your position is and what you're trying to defend. But that's why I said AI is not the end all be all. This stuff can transcribe and still be wrong. So
right.
I
Blame
know-
the AI.
the GPT.
And then I asked her, I was like, "Hey, did it notify you that I'm transcribing this thing?" And she's like, "No."
No, but there
And
was
then-
this one little
and-
tiny icon that
Yeah.
was like these little diamonds, and when I hovered over it, it said this call is transcribing. I'm like, oh my god, they didn't even tell me.
Right.
So
So
that, I mean, I guess it's not contract related, but I've recorded clients in the past, did not ask for consent, so
And now-
they did. But maybe they saw the
I'm gonna
icon.
erase this from.
yeah.
Erase
Cut
all
it.
this.
You're going to jail. But it's more to, but then I guess it's not really protecting us, because a lot of times what happens when you're talking to clients and everyone's excited and there's like a brainstorm, they're
Yeah.
like, oh, we're going to get this, and then there's budget for this. So it's recording to do a recap email, kind of being like, hey, just want to remind you of everything that
Yeah.
you said we were going to do.
And that's fair.
But is it
I think
fine?
that's okay.
Is
no,
it,
No.
who's the attorney here?
Sorry.
He's like, you're
I
good.
am licensed now from this conversation.
You have now been licensed.
ChatGPT law degree.
Thank you. I think what she's trying to say.
No, man, don't speak for me, man.
Okay, no,
I got a microphone.
What she is trying to say,
What I'm
what she
trying
is
to
trying to say, not what she's trying to say, is that you record the conversation to be able to transcribe it later, because we didn't have ChatGPT
Yeah.
back in the day,
Yeah.
or at least AI transcribing those
Yeah.
things. So then later you can read it or listen to it over, write the
Yeah.
follow-up email,
Yeah.
and then send them the
Which
Yes.
I've done too.
But
Okay,
is it
thank God.
binding for the client confirming via email? Like, is there any protection there, or there still has to be like a contract? Like, hey, we discussed this, that you're gonna have budget for X, Y, Z. Like, does an email do anything at all?
As to the recording part, I think it's fair to tell them up front, hey, I'm going to record this call because for my notes, for our records, just to write it down, I'll just destroy it, I'll delete it after our call, but I just want to make sure that what the information I'm telling you is accurate, or what I'm remembering from this conversation is accurate. And as to, what was your second question?
I guess the second part, it would have to be in a contract. Is like sometimes
Oh,
when you're
yes.
talking about a project, there's like numbers
it
involved.
depends.
Or, yeah.
Does your contract make way for expenses or approval of expenses before they're incurred, or is there a presumption that the expenses that you're incurring are reasonable and that the client's going to cover them. So you want to make sure that the language is consistent with what you're doing. So it sounds like you're contracting to be revisited.
It sounds
girl.
like you have
Yeah.
to hire you. Okay, perfect. Thanks.
Yeah, so that happens all the time, right? You agree on a project, you agree on a budget. When you jump into a couple of creative meetings, things get a little bit out of hand by the company that wants
Yeah.
these things. So it's important to let them know, hey, this was out of the scope of work, but I am still willing to do it. You just got to give me more money.
Yeah.
And then
And that should be in writing.
Exactly.
I always include, these are the estimates, the initial deliverable costs or the payment terms are initial estimates, and they're subject to change based on our agreement in writing or, the service provider's expertise and that these expenses are reasonable. And it's always something that should be, confirmed between the parties. But to your point about, is an email going to do anything? It depends on what your agreement says. But if you're saying, hey, this is going to cost this much extra, and they're saying good to go, then what are they going to fight about?
But she should re-evaluate the contract and add it
Okay,
in there, no?
plug.
Right? Well, I'm just saying.
No, but yeah, I guess what I do. Thanks.
He said, but she should hire you, right?
Oh, he better get a little commission.
I am her attorney now. No, I'm kidding.
So what you're saying is, I didn't know this. So the contract could have some wording where it says that if a budget shifts or things expand, the scope of work changes, that just writing after that can be binding?
Yeah, it
Okay.
can say, the initial estimate, subject to, your discretion, or as agreed upon by the parties, it may be increased or decreased depending on the direction or delays or additional expenses that are occurred. But yeah, that's definitely language that I encourage to be
Yeah.
included.
No, that's like a big part of this work. It constantly changes, like the budget, and
Yeah.
it's always like, do you send then a second contract, or like what happens?
Yeah.
Okay.
Do you revise the
Yeah,
contract? Like what
exactly.
happens?
And they're excited, so they don't want to be annoyed with another contract. and-
Exactly.
yeah.
So it can just be a schedule where, okay, so the payment terms say that, this initial estimate is based on the deliverables listed. Anything beyond that, the scope of work, are subject to additional fees and costs. And then that can be something that you agree to in writing later on in an email.
Perfect. Good to know.
Good to know. Yeah. Thank you. The licensed attorney.
You're like, I need that.
I'm going to write that down.
I thought you were licensed.
I was going to ask, so should things like that be in like your company policies, so that you can just communicate it via email, and not really have to put it in the contract? Like that could be something that is kind of standard for you to just add on because it's
Yeah.
company policy.
Yeah, I think that, okay, so employment policies or company policies govern how your company operates internally. So within your contractors or your employees. But I think that's better fit for a master service agreement. Like, this is how we conduct business. And then we have schedules tailored to each client's needs or the purpose, but these are the concrete terms of how we run our business. Like, additional expenses are approved between the parties or in writing or verbally or whatever works for you and your business. And again, things that you're going to follow. But yeah, that's how I prepare the contracts, right? You have the master service agreement because those are the concrete terms, and then the schedules can be adjusted.
Okay.
Yeah.
I have another question.
Yeah.
This might be off, but when it comes to contracting models to shoot for a client, what's the approach on the contracts? Do I make it my client's responsibility, or like, I think I have difficulty with that just because if I'm hired to produce the content and I produce even sourcing the models, then will it be my responsibility if they come at me and they're like, well, why did you use this for a website? I took the photos for a catalog or whatever.
So she's saying if she's producing the work.
He's a translator
Sorry.
and a licensed attorney.
This is like
Well, 'cause
specific. Yeah.
No, no,
You understood.
Yeah.
Well, you were a model yourself, so you would know, no?
So it depends on what's in your contract. So that can be something as easy as, a schedule that has line item deliverables, and you check mark, for this project, we're also sourcing the models, and this is the fee for that. So that they know that this is additional services or this is what's included in the deliverables, but they're also prepared to eat those costs. Like, it's not something that you have to worry about. Like, you're also hiring me for this. This is what's additional, and this is what we got to pay the models. Like, it's included.
Yeah.
Does that answer your question?
But you're saying if the model...
The responsibility of the rights to
Yes.
the photos. So the brand is hiring me independently to produce the content, but then I end up eating the responsibility of the model being like, but you don't have the right to use my photo like this or this or this. You only have the right to use it like this.
Mm-hmm.
Do I create a contract between myself and the model as the independent contractor?
You don't have one already?
No, girl.
Yes, you need one.
Okay.
It can have
Or
photos.
do I make it the brand's responsibility?
No, because the brand is hiring you, and
Okay.
then you're contracting out the models.
Yeah.
If it's somebody that maybe there are some circumstances where the company is hiring the models directly, and then you're working with those models that they contracted, then you don't have to worry about what their
Yeah.
agreement is with photo release and stuff. But if it's someone that you're responsible for contracting, then you need to make sure you have something in writing with them.
I would just create a general release agreement, and
Okay.
wherever this thing goes, you've signed that
Yeah.
it's okay.
Yeah.
That way you protect yourself as the agency, and you protect your client as well,
Yeah.
because there's so many like variables there.
Yeah, you might not want to tailor that to, the model can use this for her portfolio. It's like, you don't know what the client's gonna want or what they're gonna allow. So I think definitely having a general photo release or, work for hire type of language where it's like, this is being produced for my agency, not even the client, this for my agency.
Okay.
And you don't have rights to that unless otherwise stated or agreed upon.
Yeah, and that'll protect you mainly.
Yeah.
But if something does happen, which we spoke about this yesterday too, that a couple of friends of ours got hired to do a Hard Rock shoot, and it was licensed for only South Florida, and you and I were, well, not together, but we saw it in Italy separately.
Yeah.
Like her friend as a model, and then my friend as the photographer who took the picture. We saw the image in Italy at the Hard Rock in Italy, and I sent a picture to my friend like, "Oh shit, your stuff is in Italy," and he's like, "Wait, what?"
Oh, wow.
So that happens, and that happens on the model end, and that happens on the
Yeah.
creator end.
Yeah.
Yeah, both.
It's important to just.
For sure.
In that case, what do? You sue Hard Rock?
Good luck.
Yeah.
Yeah, that's why. You're like, whatever, keep it, I guess.
You should have
You're
allowed
like,
that one.
be happy
They got a
that it's in
team.
Italy.
They got a team.
They
Those
got
Seminoles
a-
don't play.
Yeah, they don't. You have a question, Gia? Can I see? Okay.
This was really interesting with with the model piece, right? Because I feel like a lot of creators, you intersect in some way or another in this work, regardless of what your medium is. But if, for example, if you're not the agency, or if you're the client, if you're like hiring models for your business, no one else is involved, does a media release form stand for a contract and that collaboration with the model, or do you need additional paperwork outside of the release form when working with the model, you for you, not just like other businesses or clients?
Yeah. So if my client is the company hiring models directly, they should have a service agreement with the model, and it could include in their photo release or IP rights and in the works that are created with using their likeness or image or whatever. I think we need to talk about this concept of privity. So privity is when someone is a party to a contract. And in Lisa's example, where she's working with a client, she's the middleman, and then she's contracting models, the client doesn't have a contract with the model. It's like there's two contracts in place. So who's the party to the agreement with you? Is it the model or is it the agency? And then you modify accordingly.
Got it. And I have one more question, sorry, but it's more of a general one. It's not necessarily tied to contracts. Is that okay?
Yeah.
So, because you've worked with so many, right, like creatives or businesses in this field, entrepreneurs that specifically in creative work, I think we can all agree we're not the best prepared at independent creators, at least in this field. Have you observed any like common mistakes in general, whether it's trademarking, copywriting, contracts, licensing? All of the licensing piece I think is interesting as well to explore. But from your experience, are there common mistakes that I've seen creators do this a million times?
Yeah.
I've seen creative entrepreneurs do this a million times. It's not okay, something like that?
Yes. So many IP issues because IP, like I mentioned before, is such a nuanced thing. Like no one really understands what it is. And what happens consequently is creators and businesses don't know what they can protect or what they can monetize off of. So work for hire or independent contractor situation is a good example that, you know, let's say you get hired to create this video or these photos. Now you're just assuming that they're not yours, or you're assuming that they are yours. What's in writing? Like, do you have permission to use them for your portfolio or on your page or for marketing or for your personal? Or are you completely restricted? Is the work you created solely belonging to the company and, you know, you don't have any rights to them anymore? So that's one thing, is knowing your rights and knowing what your contracts say. We talked about some of these.
Yeah, we talked about how creators forget that work is theirs unless stated otherwise in a contract somewhere by whoever hired you. You know, these cameras, you buy them yourself. Those SD cards, you buy them yourself. They're yours. And whatever you're creating with those tools is essentially yours. Yeah. And people nowadays here in South Florida mainly just give that up so easily. And there isn't a usage clause in their contracts. A lot of these guys don't even have contracts, which is very sad, you know? Even if it doesn't have to be 5 pages and have the crazy words or the verbiage, but just having something in place where it protects you and protects your asset, which is the creation that you're making. You know, these pieces of equipment are assets because you use them to create, but what you're creating with these pieces of equipment are bigger assets.
To add to that equipment topic, who's covering you if your equipment gets damaged? Does your contract cover, you know, somebody knocking into your lens and breaking your equipment, your $2,300 lens? Like, who's covering you? So having that stuff in writing is important too. And just to exemplify how important it is to know that what you're creating is yours, I have the perfect case example. So J-Lo got sued like 2 weeks ago for reposting a picture that a paparazzi took of her. She assumed that she had rights to the picture because she's that, you know,
it's her.
It's her picture. But no, actually, without permission or a license from the paparazzi, it's the paparazzi's work. He is the photographer, he's the creator, he's the author, and he's the owner. So he's suing her for $150K right now for a post on Instagram. Wow. And she's not the only celebrity to get sued by paparazzi. I mean, publicity rights is something that's so crazy, and I think maybe that's something that we can reserve for another talk.
For sure.
But that just goes to show the potential of creation and ownership and knowing your rights. Because imagine this person letting J-Lo monetize with her 83 million or however many followers she has, and he didn't know he could have a little cash grab. I mean, it's crazy to me, but it's the law. Yeah. He has rights in that. Yeah.
I'm sorry, it was just tied to this. I found it so fascinating. So for example, if you're a creator and you get like, you go to an event, there's like Getty photos or whatever photographer of the event or anything, and you post those from an event photographer, that means that you could be sued by posting event photography with yourself on social media. If you use that event photography created by someone else and you don't pay them for the event photo you got. Does it make sense?
Yeah.
Even if it's like a red carpet photo or like, I don't know, something like
Yeah.
that. You can get sued for
Especially in
posting a red carpet photo.
especially in a private space too, because I would
It
understand
belongs to the person who owns the space, right? Or who rents it or.
Well, let's not get. I don't want to get too into publicity because that's not why we're here today. But I want to say that, you know, if you're suing somebody, it's because they have money, they have assets that you're going after. So, is a paparazzi suing, you know, a girl that they took a picture of at the club? Like,
Yeah, I think if if Getty Images takes a picture of you and you post it on social media, they're most likely not going to sue you. They're going to probably send a cease and desist.
But there is exposure there for sure because you need permission.
Yeah.
Even if you're, you know, the model or the art or the subject.
Yeah.
Thank you.
So if it's on your own platform, you can share it and then you own the rights to that. If it's your own website, let's say, nobody else can repost what you have posted on your website, correct?
It depends what you're posting. Is it something that you
Work.
created?
Yeah, work related.
But
So
is
let's
it
say I
yours?
don't post it on social media. I created it. I have the
Yeah.
design,
rights.
right? If it's on my own platform website, then it cannot be shared and I can sue for that.
It depends.
Okay.
If you have copyrights, if you have federal registration, you can sue in federal court. But if you don't, then you're stuck demanding somebody to take the content down. Okay. And a good example is I had an old client who was a wedding and event photographer, and they had their, you know, portfolio up on their website, and there was another company claiming their photos as their own, another wedding photography company, and they were reposting their photos on their website, like if they took those pictures. And so they didn't have copyrights, because are you going to copyright every wedding that you do? You have to select, you know, pick your poison. But we did end up having to demand them so that they can take them down. And unfortunately, we didn't hear back, because sometimes you take the right steps and it still doesn't get anywhere unless you go to court. And in order to go to court for copyrights, you have to have a registration.
Step one.
Step one,
I
protect
think
yourself.
moral of the story,
is register.
trademark, copyright before you even put it out, because us as creators, we're so excited to get the work out until we're stuck in a situation where we have to hire Carissa.
Well, let me clear a misconception about lawyers, okay? There's this negative connotation behind being an attorney, hiring an attorney, needing an attorney, that, you know, there must be a problem, you must be getting sued, it's gonna be expensive. But that's why I love what I do, because I get to help creatives and entrepreneurs make their dreams a reality and conceptualize and monetize off of their creations, rather than it being an issue and now you have to hire me. So that's that preventative law that I practice. So it's like we're anticipating the issues and we know how to navigate them if they do come up. Amazing. So it's not always negative.
No, I'm not saying. I'm just saying, you know. With that being said, I wanted to say thank you so much, Carissa, for taking the time to educate us on everything IP and beyond, contracts, all that good stuff. I would love for you to tell our audience where they can reach you when, and it should be soon, need your services.
Thank you. Again, thank you, Kendrick, for having me, and the HGAB team for putting this event together. And to everyone in this room, thank you for being here. My name is Carissa Rivera. I'm a business and intellectual property attorney licensed in Florida, and I'm the founder of 222 Legal. You can find me at 222 Legal on Instagram. 222-legal.com is my website. You can set up a free consultation with me to talk trademarks, copyrights, business contracts, all that good stuff. And I think this went well, right?
Yeah.
I think we did good.
I think we did great.
For ChatGPT.
I think we killed it. Yeah. Again, thank you guys so much for coming out tonight and hopefully learning a little something about this legal world that we live in as creators. Yes. And this is something that we're going to be doing at least once a month, where we find different topics to educate our creative community, our beautiful creative community down here. And then we're going to be doing a lot of stuff together, hopefully, pretty soon, to continue to educate you guys and get you guys on the right track to being successful as a creator.
So maybe you can let us know what topics you want to learn about,
Yeah.
things that you want to avoid, things you want to know. And I do have a homework assignment for everybody. I invite you all to ask yourself questions about how you're operating your business and how you can continue to grow it and protect it. If there's a gap in your process, I can help you out.
Yeah, come find me.
No, but in reality, we can get on a consultation and I can give you information. And I'm just excited to be able to give back to the creative community and, continue to empower like-minded individuals to protect themselves and make that money.
Facts. Thank you again, Carissa.
Thank you, Kevin.
Appreciate it. And thank you guys again. And that's a wrap, you guys. Thank you so much for joining us at the Something Cool panel. Oh, yeah. Where are my cards? Bro. Oh, yeah. Go for it. Yeah!
Sue him.
You threw it. Thank you guys for joining us tonight for Something Cool. We're super excited to continue this on a monthly basis. And we hope to see you guys very soon. Thanks, guys.